Hello everyone and welcome to Gowling WLG's Think House Antitrust Update. I'm David Lowe, one of the organisers of our Think House events. I'm a commercial contracts lawyer and Michael Luckman and I have for many years put together the Think House event. I'm really sad that we're not doing this in person. Sam and I are here in the office in separate rooms, but unfortunately we know we're not quite in the place where we can do big events. So we unfortunately had to resort to doing it online. That does mean that many of us have been able to join us. But for those of you who are new to Think House, we hope you enjoyed today's session. Think House Autumn is made up of 4 sessions. We have today the antitrust update, but this morning we had data protection. Next Thursday, we have the in-house lawyer's guide to COP26, and then followed by a session by myself and Emma Carr about what to do when contracts go wrong. By subscribing to this event, you will get a link after all 4 of the events with all 4 recordings and all of the slides for all of the events. So you will have the opportunity to relook at the slides, relook at the recording, and indeed share it with your colleagues. We're delighted if you wish to share it. That would be absolutely great. But anyway, today is about antitrust. You know, we all love it, we all hate it really, don't we? Because antitrust, it gets in the way, it's complicated, it's challenging, it changes, and it can have a very big impact if you get it wrong. And that, unfortunately, is why it's important for us all to have an understanding of antitrust law. Because if you get it wrong, well, you could end up with a dawn raid or an investigation, perhaps even go into prison. It also shapes your business model and your competitors' business models, throwing up opportunities and threats. So it is important medicine for us all to take, isn't it? For us all to get a taste for the antitrust law and how it's changing. So I'm really pleased that today that Sam Baton in our antitrust team, a partner in our antitrust team, is joining us to give us an introduction to antitrust changes and where we think the near future is going. Sam.
Thanks, David, and thanks all for joining. I think taking a step back, competition law, what happens next? We're obviously post-Brexit, we now have COVID-19 giving us the concept of the new normal, but lots and lots of social and political changes in recent months. So what next for UK competition law? What I'd like to focus on today are 4 areas: distribution models, UK merger control, green cooperation, and dawn raids. And I've chosen to focus upon these areas amongst the many moving parts of the antitrust universe, because I think that these are the areas that are likely to have the greatest impact going forwards in terms of business planning. So these are issues that matter for businesses today. So starting off with distribution models. Now, I'm sure you will all be well familiar with the vertical agreements block exemption regulation, which I've defined as the EU waiver for the purposes of this session. Now, the EU waiver established a general safe harbour with certain conditions of entry to that safe harbour. But within this safe harbour, there's an assumption that competition concerns do not arise. And this safe harbour is primarily available to arrangements between parties at different levels of the supply chain. There are a couple of exceptions to that, but by and large, the EU waiver is thinking about vertical, it's addressing vertical relationships, therefore distribution arrangements. And what you therefore see is the majority of distribution arrangements have been crafted to fall within this safe harbour wherever possible. So where you see a non-compete provision lasting for 5 years or less, that is an echo of the EU waiver. That is there as a consequence of the EU waiver. This is something which numerous business models are reliant upon, this safe harbour, this certainty. The EU waiver has shaped and formed how distribution arrangements are drafted in the UK and has done for many, many years. So against that background, it's important to note that the principles of the safe harbour, they still apply in the UK, even post-Brexit. But the current UK safe harbour is due to expire at the end of May next year. Now, the CMA, the Competition Markets Authority, has been considering what should replace this. Consulted on proposals over the summer and is due to make a recommendation to the Secretary of State this autumn. So what can we expect? Well, I think the really good news is more of the same. And I say that's good news because the CMA clearly recognises the value of the safe harbour principle. Now, there were some calls from certain quarters to scrap the safe harbour. Is it really needed? Is it relevant for business today? Is it not just a hangover from the EU? But in the consultation process, the CMA received a clear message from business and practitioners, and that is the safe harbour principle is very, very welcome for businesses. That legal certainty of the safe harbour is a good thing. I think another plus point around the CMA's proposals is that key aspects of the safe harbour are unchanged. So I mentioned that a lot of arrangements in place already have been based upon the EU waiver. They've been shaped and formed by the EU waiver. So the good news is the key aspects of the proposal, they don't really change those aspects. They stay the same. So market share thresholds, the conditions of entry, they will still be in place, up to 30% for each party. It's still the case that agreements, including hardcore restrictions, cannot benefit from the safe harbour. And it's still the case that certain provisions, such as non-competes lasting 5 years or less, they can benefit from the safe harbour. There's a familiarity with the proposal, which again, I think is to be welcomed. I think the even better news is that the proposed safe harbour should bring more flexibility for distribution models. And I think that has to be right, given that when the EU waiver was drafted back in 2010, the world in which we all lived then was very, very different to where we are now. In particular, e-commerce has changed things. And what I think is a really important takeaway from the CMA proposals is there is a clear recognition of online sales as a discrete channel. And equally, there's a recognition of the possibility of having different fulfillment options. It's not just about exclusive distribution and selective distribution. There are other ways to market that are being recognised. I think also really helpfully, there's a broad alignment with the EU. So the EU is currently itself considering what should replace the EU waiver. Where the UK is landing via the CMA's proposals is a broad alignment with the EU's direction of travel. And clearly, the closer the alignment between those regimes, the less there is in terms of a compliance burden upon businesses who are active cross-border. I just want to touch on a couple of those themes and explore them a little more closely. So picking up first on online sales restrictions. So today, as things stand, the following restrictions would be deemed hardcore restrictions. So they wouldn't be able to benefit from block exemption. They would need individual exemption. The agreement itself couldn't fall in the safe harbour. For some businesses, this is in the too difficult pile. You therefore just don't put the restrictions in your agreements because you want to make sure you're in a safe space. So you cut them out of your agreement. You exclude the hardcore restrictions. So what are these hardcore restrictions? So the first is a hardcore restriction on suppliers charging distributors higher prices for products to be resold online. And the other is suppliers requiring distributors to adhere to criteria for online sales that are different to the criteria for in-store sales. Now, the concern back in 2010 was that these types of restrictions, they could really be used by suppliers to squeeze distributors, to limit, to inhibit online sales. You know, what we now find those online sales is in a very different place compared to 2010, revolutionized by things such as 4G, 5G, very, very different world. And the CMA proposal recognizes this. The CMA proposes that both of these restrictions should be able to benefit from the safe harbour. So within that proposal, there is a clear decoupling of this link between online and in-store. And if that is adopted going forwards, this would give businesses clear opportunities to start to think how they can optimize these different sales channels to complement, provide omni-channel experiences. There's a whole plethora of options that open up once those restrictions fall within the ambit of the safe harbour. Another area to touch upon briefly, fulfillment options. So today there are grey areas. The 2010 guidance doesn't cover how some business models have evolved. So for example, can a supplier appoint a distributor, have that distributor act for them for certain products, and then have that same distributor act as an agent for different products? That's not covered by the guidance. There's been a DG Comp paper published relatively recently, but there isn't a clear statement of intent from the CMA post-Brexit on what that means for the purposes of its own enforcement activities. Similarly, can suppliers set the resale prices to be charged by fulfillment service providers? Does this risk straying into resale price maintenance? Is it legitimate? Again, it's a grey area. What the CMA is proposing to do is to provide additional guidance to address and clarify what is permissible around these issues. And I think what we should expect from that is more fulfillment options and the availability of different models and routes to market. And hopefully this should then enable more efficient allocation of risk, bringing more products to market and making them available to more consumers. So just to close on this part of the session, as I mentioned, the CMA recommendation is due soon. And I think what we can all expect from that is to see a new UK specific safe harbour, and for that to be in place from the 1st of June next year. The majority of businesses, I think, can expect more from this new safe harbour. I think that means more choice, more ways to allocate risk in and around distribution models. I think it gives more opportunities for online and offline to be distinct and complementary channels. And I think what we will also find is that, as ever, the devil is in the detail. So I think this is one that will be coming to a Think House event near you for further consideration once we have a clear line of sight in terms of how this will be landing. Moving on to the second area that I wanted to focus upon, UK merger control. And I think at the beginning of this segment, it will be remiss of me not to mention that there are a couple of ongoing consultations relating to merger control, as well as other aspects of the UK competition regime. So we have a BEIS consultation looking at reforming competition policy, and a joint BEIS DCMS policy consultation thinking about digital markets and introduction of a new competition regime for digital markets. I am not going to discuss these in detail because there's a whole raft of proposals within them. Again, I think this is one for a future event to think about where this is landing. I flag it for completeness. If you are interested, be aware that closing date of 1st of October will be with us before we realise it. What I would like to focus upon, though, in this segment is the CMA's updated merger assessment guidelines that were issued in spring of this year. And the reason I wanted to touch upon these is because I think they draw out some interesting themes, they crystallise some interesting themes. So we see a movement away from the CMA focusing upon market shares in merger analysis. We see the CMA placing a clear emphasis upon available evidence. And there is a note of caution as well regarding parties seeking to position arguments around entry, expansion, and efficiencies. And as I will explain, to my mind, the CMA's approach clearly reads on to transaction planning, parties' activities going forwards in terms of buy and build strategies. There's a lot going on there for parties to factor into their analysis in terms of how they plan deals going forwards. So starting with market definition and market shares, the CMA uses market definition as a tool to assess competitive effects. And it does this primarily by considering the main competitive alternatives that are available to parties' customers. So from a customer's perspective, what do they see as alternatives to the emerging parties' products? And where would they buy those alternatives from? Where would they source those alternatives from? We generally see a market defined by reference to both a product market and a geographic market. So for example, the supply of widgets in the UK, which you would see in any competitional textbook covering competition law in the UK. I want to just explore a little bit more how the CMA thinks about product markets and geographic markets. So product markets, which products are viewed as alternatives? Well, the CMA focuses upon evidence including the actual characteristics and intended uses of the products or services. It also looks at the parties' internal documents, and we've seen in recent years a real focus upon the parties' internal documentation. What were the parties writing before the transaction? How do they really see their sector? What are they really competing with in terms of products? The CMA also will canvass the views of customers and competitors. And what we find in practice and what is apparent from CMA decisional practice is that product markets can actually be very narrow, and they can be much, much narrower than parties in their minds may think. And I've given here the example of the Christmas pudding. The Christmas pudding, which was found to be a product market in and of itself, distinct from puddings, distinct from steamed puddings, but a market for the Christmas pudding. Thinking about geographic markets, again, the CMA, when it's thinking about the areas in which a business competes, does focus upon the evidence. And when it's thinking about the evidence, that can range from looking at catchment areas. So if there are a number of sites, where does a given site make 80% or more of its sales? What's the focus of that site in terms of its geographic footprint? How do other firms fare? Firms outside the area, can they compete effectively in that area? Is it the case that firms can readily come in and compete? The customers have preferences. In certain sectors, customers have a very, very clear preference for local supply. And you can point to there being a range of different suppliers from further afield. But in reality, if customers want to have a local supplier, that is where competition will be most intense. And again, with geographic markets, these can be very local. I've put here the example of licensed betting offices, and licensed betting offices have previously been found to compete with other licensed betting offices within a 400-meter radius. So a very, very local market. But what if you can point to a large market? What if you can say, it's a huge market, and that means we've got really low market shares? There's no issues from that, right? It shouldn't be a concern. Well, market definition is not a silver bullet. And this is what the merger assessment guidelines make very clear. In market shares, they don't show you how parties actually compete, and they don't show you how parties plan to compete in the future. So they are a static snapshot. And because of that, the CMA is increasingly focusing upon competitive assessments. What that means is, on a case-by-case basis, the CMA is conducting an analysis. It's thinking about, for the sector under consideration, what parameters of competition are most important. How do firms currently compete in the sector, and how are they going to compete in the future? Really importantly, how closely do the parties to the transaction compete? And are they going to compete more closely in the future? And after this transaction, the firms that are left in the sector, will those remaining firms impose sufficient constraints upon the parties so they're not in a position to exploit the position in the sector following the transaction? And in conducting that assessment, the CMA will focus upon a broad range of evidence. Internal documentation, as I mentioned, that is a goldmine evidentially for the CMA. Views of customers and competitors can be very important when thinking about closeness of competition and alternatives. Bidding data. We see lots and lots of cases where the CMA is very keen to analyse bidding data, where parties are in markets characterised by tenders, and to see how customers would switch. What's the competitive interaction based on customers switching or threatening to switch between the parties? Also, how do the parties respond to each other, as well as other competitors? Who, if you look at the data, if you think about pricing trends, who moves on price, who follows? How does that map out over a period of time? And the rationale for the transaction, what is the acquirer's reason for doing this deal? And how has the acquirer valued the target? And in transactions where future competition is likely to be more of a concern, that valuation from the CMA's perspective can be quite telling. If the acquirer is paying a very high price for a target with currently very limited activities, what is the reason for valuing the target business at that high price? I just wanted to pick up a couple of examples from recent decisional practice of the CMA thinking about some of these issues. So the first is the JD Sports with Asylum transaction. And this transaction, the area I'm focusing upon, related to the retail supply of sports-inspired casual apparel online nationally. I think that means selling stuff like this online to customers. So what the parties in their market share analysis presented was a combined share of 20 to 30%, a modest market share. That's something that's not raising alarm bells. 20 to 30% in a market, lots of players in that marketplace, shouldn't be a cause for concern. However, the CMA, digging into the market, concluded this was a highly differentiated market. There were lots of players, but there were lots of different business models. The parties, however, were close competitors, And the CMA looked at the parties' internal documentation in particular and reached that conclusion. So the parties were close competitors. There were only 2 other players of a similar size. There was a long tail of smaller competitors, but they only imposed limited constraints. So in effect, this became a 4-3 loss of competition type scenario. And that gave rise to a clear concern from the CMA's perspective. And this concern, in conjunction with others, led to the CMA requiring JD Sports to sell Footasylum. So the CMA ordered the undoing of this completed transaction. Another case to touch upon is the Breedon Cemex transaction. I'm focusing here upon the production and supply of ready-mix concrete. This necessarily has a relatively local market because you cannot drive cost-effectively ready-mix concrete particularly far. I think it's got about a sort of half-hour drive time in terms of where you would supply this from a site. So in one particular local area, the combined share of the parties would be around 30 to 40%, somewhere in that bracket, and there'll be 7 competitors remaining in the area. And again, this is a market share level and a competitor mix where you could look at that and say, market shares, not that high, lots of competition, shouldn't be a problem. However, the CMA, in looking at this transaction, effectively segmented the competitors and said there were some competitors, the major competitors, who were more important than the other independent competitors, the smaller competitors. And this particular transaction in this area resulted in a reduction in the major competitors 3-2. In addition to that, one customer raised concerns about a lack of viable alternatives, and a competitor raised concerns. They alleged there would be issues of dominance post-transaction. And on the back of the CMA's analysis, it found that yes, it considered there was a concern in relation to this particular area, and the ready-mix concrete site was therefore required to be sold to a third party to address those concerns. That's a little bit on market shares, CMA approach. I just wanted to touch as well upon arguments relating to entry, expansion, and efficiencies, because parties who wish to position these types of arguments, they are going to need to evidence these arguments, and evidence around claimed entry or expansion will need to be timely, likely, and sufficient to prevent competition concerns arising. So for high-level concepts about it's a 4-3 transaction, but don't worry, it's low barriers to entry, anyone can come in, it won't be a problem. That is not going to wash with the CMA. And what the merger assessment guidelines make really clear is that if competition concerns are identified, entry and expansion arguments are rarely going to resolve those concerns successfully. Similarly, with efficiency claims, where parties are saying, there may be a potential competition concern, but actually the transaction overall will give rise to efficiencies, and therefore those efficiencies should bear out, should overcome these competition concerns. Again, the merger assessment guidelines, as published in spring of this year, make clear those types of claims will only rarely succeed. So if you are thinking through transactions, if you are thinking about risk, if you find yourself falling back on these as potential routes to a clearance, I think this is a very risky place to be. So I just wanted to give a couple of comments before closing the session. And I think that's to emphasize that if you are planning transactions involving businesses in the UK, and the merger control regime in the UK applies to those, be mindful of the CMA's approach. And I think what that really boils down to is looking beyond market shares and thinking about the impact. So what is the impact, not just on current competition, but also upon future competition? And if you really stripped it back, if you looked at the players and actually said, of these 10 we've listed as competitors, maybe only 5 of them are really competitors, and maybe only 4 of them in certain areas are actually competitors. What does that worst case scenario look like? If the CMA really looked at this and drilled down and segmented, what's the worst case scenario? And if you've looked that worst case scenario in the face, is the transaction still viable? And if it is still viable, who is going to bear the CMA risk? because that'll be a question on the table. If there are concerns, if there are potential issues, who is going to be the party, who's going to bear that risk, and how does that get factored into the commercial negotiations in respect to the transaction? One last point to flag in this area is the National Security and Investment Act 2021, the so-called UK FDI regime. You will have heard about this because it's been covered extensively in both press and also various law firm updates. This will fully enter force on the 4th of January 2022. And what this introduces is a mandatory notification requirement for certain transactions in 17 deemed sensitive areas of the UK economy. In addition to that mandatory notification requirement, the Secretary of State can call in other transactions. The transactions that aren't subject to notification requirement can still be called in by the Secretary of State. When the Secretary of State is considering transactions either notified to it or called in by it, it will consider whether these transactions give rise to national security risks, and the Secretary of State is able to impose remedies to address any such risks. This is a topic that we have recently contributed a chapter addressing the UK FDI regime in the context of international regimes. That will be published online shortly. We can obviously make that available to attendees of the session today. We will also be following up with subsequent sessions. So again, one to watch out for in terms of this hot topic around UK FDI. Moving on then to the third topic I wanted to touch on today, and that is green cooperation. Now, green cooperation is something which we really see coming out of the climate emergency. So there is currently a clear call to action. Now, what can businesses do? Well, there are a growing number of proposals for competitors to cooperate, to find solutions, to find ways forwards, to find solutions in the context of the climate emergency. And I think partly that's been inspired by the COVID-19 pandemic. Again, another emergency. And the response to that emergency was to relax some of the competition laws, to make it easier for competitors to get together, to find ways forward, to keep supply chains running, to make sure that groceries were on shelves. COVID allowed relaxations. So I think there is a question about, well, what about green cooperation? Why can't we do more now as competitors to find solutions to address this emergency? So this is going to be the next big thing. I think in antitrust circles, this will be the next big thing for companies, for businesses. They will either be seeking to put initiatives together or be invited to join initiatives. This isn't going to go away as a topic. But before moving on to thinking about where we are now, what I wanted to do was just have a look at how competition law has applied previously in the context of green cooperation, and to see where that has worked well, and also where some of the pitfalls have been for businesses and the challenges they have faced in that context. So the first case I wanted to touch upon was a commitment around CO2 emissions given way back in 1998. And this emanated from a trade association, the Association of European Automobile Manufacturers, ACEA. A commitment was made to reduce CO2 emissions from passenger cars. And that commitment was to be jointly monitored by EU member states as well as the Commission. And if the target was not met, the Commission would consider introducing legislation. So there's a clear incentive for players in this sector to find their own way forwards and avoid the Commission stepping in to introduce legislation outside of their hands. What the commitment did was it applied an overall average target for all members. And what that meant was the commitment did not impose a target on individual manufacturers. So manufacturers without individual targets imposed were therefore free to apply more or less stringent levels of emissions. And they were also free to develop new technologies independently and in competition with each other. And because of that, this commitment was found not to be restrictive of competition. Fast forward a year to washing machines, and another case emanating from the activities of a trade association. In this case, the members of the association, they actually agreed to stop producing or importing washing machines in the lower energy efficiency categories. And by doing this, what the members effectively did was they introduced a new energy efficiency minimum standard. So the cheaper energy, the less energy efficient machines were no longer going to be something they concern themselves with. They were raising the standard and focusing upon the more energy efficient machines. And what this meant was the agreement necessarily prevented the parties from competing across the full range of categories. They deliberately said, we won't do these ones anymore. So necessarily they did stop competing. However, while being restrictive of competition, it was found the agreement was nevertheless capable of individual exemption. So it did restrict competition, but as we will see, what happened as a result of that, good things came out of this, enough good things came out of this for it to be something that complied with competition law. I think this is an interesting case to note for a number of reasons. I think the first one is that what the Commission found was that even though individual purchasers would actually pay higher prices because the cheaper machines were being effectively taken off the market, the individual purchasers can pay higher prices, but the Commission found there were economic benefits for individual purchasers. And the Commission rationalised it as such. So the machines that are available, once it's just the better machines in terms of performance, they'll use less energy, and that means they'll have lower running costs. And that means that purchasers can recoup the cost for the more expensive machine by having these cheaper running costs. And the Commission also reached the view that, yeah, the machines are more expensive now, but if manufacturers are concentrating on producing these types of machines, they're going to compete more there. And that additional competition, they will have to compete on price. That's going to be an element of this. And that should then bring the prices down in terms of what consumers have to pay for these machines. So the Commission found there were benefits for individual purchasers, but there were also collective benefits, collective environmental benefits. And what the Commission got very comfortable with was that this would result in a significant reduction in CO2 emissions. I've put here in full quotes. So the environmental results for society would adequately allow consumers a fair share of the benefits, even if no benefits accrue to individual purchasers of machines. So overall, even if the buyers didn't actually benefit, we as a society overall, we will benefit from this because of these reductions in CO2 emissions. So the Commission made very clear this agreement was expected to contribute to technical and economic progress while allowing consumers a fair share of the benefits. In addition to this, the agreement did not impose restrictions that were unnecessary to attain these benefits. So it didn't prescribe the technical means required to meet this new minimum standard, and it did not limit any other aspects of the parties' commercial behaviour. In addition, the agreement did not actually eliminate competition. So the range of technical options available to meet the new minimum standard was widely available. The manufacturers could all access different options to meet this standard. They could compete on a range of other factors in the remaining energy efficiency categories, including price, brand, performance, and the effective machines actually represented quite a small percentage of the overall sector. So the agreement was capable, therefore, of benefiting from individual exemption and was therefore compatible with EU competition law. Now, we've looked at where things have been compliant. I now just want to briefly look at where things have gone wrong for parties, where they've started out in green initiatives and then things have taken a turn for the worse in terms of outcomes. So we're going to 2011, we're talking about washing powder. Again, another trade association. And in the context of this trade association, there is a voluntary initiative launched back in 1997. And the purpose of the initiative is to promote more sustainable consumption of laundry detergents. Members discussed a variety of things, focusing in particular on heavy-duty detergent powder. And the aim of the initiative was to reduce weight and volume in terms of detergent powder. And reductions were to be implemented across a number of different stages. Outside of this, though, there were a number of manufacturers who were keen to ensure this initiative didn't give anyone a competitive advantage. And what they sought to do was to maintain market shares at the pre-existing levels before the initiative was rolled out. And they did that by a number of means. So firstly, they agreed on packaging formats and fill levels. And that was quite important because that then allowed them to monitor and to oversee the various restrictions they put in place afterwards. They agreed not to reduce prices. So when pack sizes were reduced, when weights were taken out, when the packs got smaller, they agreed they would keep the prices the same. So they're not going to reduce prices to reflect that reduction in volume. They also agreed to restrict promotional activities, and they agreed on targeted price increases where the market leader would move first and others would follow. Now, these arrangements clearly restricted competition, not capable of individual exemption, and no benefits here accruing to consumers, and fines totaling 315 million euros were imposed upon the parties. A more recent case, which has been widely publicised, is the emissions cleaning case. And this focuses upon selective catalytic reduction, SCR systems. And in this context, SCR systems are used in diesel passenger cars to make emissions less polluting. The case revolved around 5 manufacturers who cooperated to develop SCR systems. And the purpose was to work together to put systems in place that would meet the EU regulatory requirements for emissions levels. And the manufacturers did that. They were successful. They actually cooperated, they got things to market, they produced technologies in a timely way that benefited consumers and the environment. So everyone was happy, and that was the end of the case. Only, of course, it wasn't, because otherwise it wouldn't be in this section. So what went wrong? Well, the cooperative manufacturers, in the course of their cooperation, they realized they didn't just meet the regulatory requirements, they could actually exceed the regulatory requirements. And they then opted not to compete on the effectiveness of the SCR systems. And they colluded by indicating to each other that they would not seek to exceed the regulatory requirements. So in effect, they neutralized competition on emissions technologies. They did not seek to compete against each other by producing greener vehicles. And these arrangements were again found to restrict competition. They're not capable of individual exemption. Fines imposed totaling 857 million euros. I think it's notable, this is the first time that collusion on technical elements has been treated as a cartel. And the Commissioner for Competition, Margaret Vestager, has made clear that in the decision, we can look forward to this because there is guidance provided to parties about where you had here clearly cooperation that was positive and gave rise to beneficial outcomes overall, and the lines within which that can take place, as opposed to when that then tips over into this collusion, which is clearly harmful for competition and innovation and leads to suboptimal outcomes for consumers and for markets. And comments just in terms of closing this session in the time that we have remaining. I think it's just worth reiterating that green cooperation, it is the future. This is not going to go away. And I think with that in mind, it's important to remember that green agreements between competitors, they can be competition law compliant. You can structure them so that these fit within the competition rules and don't give rise to undue risk. I think what's also really clear is that green arguments, they're not going to save something that's obviously anti-competitive. Now, the space we currently occupy, we have authorities providing guidance. The CMA itself has published high-level self-assessment guidance. That was January of this year. It has intended or issued, or intends to issue further guidance in relation to green cooperation. Similarly, the European Commission this month issued a policy brief in relation to how competition law can support Europe's green ambition. It has also committed to providing further guidance in the form, particularly of the horizontal guidelines. The Commission has also indicated that it's open to discuss projects with businesses. And in some cases, it has indicated a willingness to provide comfort letters. So to say that something it thinks is compliant with EU competition law. So that, again, is a bit of a hangover from COVID-19 when we saw comfort letters coming back. Comfort letters appear to be back on the table in terms of green cooperation with the Commission. So we have the promise of further guidance, and we have outlined so far in the available guidance. We have ways forward, but I think the guidance does need to be developed quite a bit further. developed and refined so parties have a much clearer understanding of where lines sit on some of these areas that are perhaps a little more grey. So what does that mean for businesses now? Well, I think what this means is that green cooperation, I think it needs to be handled with care, and businesses should really focus on the facts. I think in particular, what is the actual rationale for the proposed arrangement? And realistically, if you take that view of worst case scenario, realistically, what would be the impact on competition? Not just on price, but non-price factors as well. What would be the impact on competition in the specific context of the affected sector? Who is going to benefit from the proposed arrangement? How will they benefit, and when will they benefit? Because if this arrangement is something that could restrict competition, I think it's really important to be able to quantify those benefits. So evidencing benefits, quantifying benefits. What happens in terms of the benefits? Could they be achieved by less restrictive means? Is there another way to do this which would give rise to fewer restrictions of competition? Because if there is, then that, from a competition authority perspective under the orthodoxy, is the preferred route for parties to go down. I think another thing to factor in is if you do have something which looks like this could be a successful cooperation, successful initiative going forwards, what safeguards are going to be put in place? How are you going to ensure there is continuing compliance? How do you avoid a situation like the washing powder case, where what started off as legitimate activity then tipped over into something that shouldn't have been taking place? I think lastly, what is the appetite to approaching a competition authority? And I say that because I think we are in a unique space at the moment with green cooperation. I think this is something which would have traction with the competition authority. The European Commission has indicated it's open to have discussions. I think other competition authorities, potentially on an informal basis, would also be happy to be approached and to at least talk through developed ideas, developed plans around what this would look like for business, what it would look like for a sector. So that's something to bear in mind. Is there an appetite to approach a competition authority? Mindful of time, I would just like to move on to my last section. Having thought about the possibility of approaching competition authorities, I want to think now about the possibility of competition authorities approaching you, so dawn raids. And I want to go back to a time when dawn raids were once a reality. And for me, I had a dawn raid kit on my desk. I was ready to go away for days at a time with toothbrush, toiletries, etc. Dawn raids were a reality. And because of this, businesses trained their staff. They created contact lists, policies and procedures were put in place. And then COVID-19 changed everything, because lots and lots of people went into their homes for months and months and months and spent hours on video calls and hours on video calls and a few more hours on video calls. And dawn raids became a distant memory. But now we're all embracing the new normal. And for most of us, the new normal means hybrid working. Sometimes in the office, sometimes at home. Hybrid working across a range of sectors. But, I say this quietly, dawn raids are coming back. And we saw in June, I remember where I was when I read this tweet. I was surprised it was happening, but it was happening. We saw in June, EC officials, the European Commission, conducted a dawn raid at premises in Germany, accompanied by officials from the Bundeskartellamt. So in June 2021, we had a dawn raid in Germany. What if the officials from the CMA arrived in reception tomorrow? Would current policies and procedures be fit for purpose? Would staff know? Would they remember how to respond to a dawn raid? So embracing the new normal, I think we all are aware this is likely to require changes to pre-COVID-19 plans. And I'm conscious that somewhere on the to-do list, we'll be revisiting the dawn raid policies and procedures. And I say this in the spirit of opportunity rather than to be a doom monger. But I think there is now an opportunity to stress test these policies and procedures in-house and to revise them as required, rather than have the CMA officials stress test those policies and procedures in real time when they arrive in your reception area. So with that thought in mind, I will hand back over to David in terms of any questions we received during that talk.
Thanks, Sam, for ending with a reminder of the terrors of antitrust law, and apologies everyone for how, with getting used to hybrid working, we ended up being having these fire alarm practice in the middle of that. Sam, we've had a few questions coming through in the Q&A, so thank you to our audience for putting those forward. First one I'm going to talk about is on the vertical restraints. One of the questions we've had in is, do you think that the CMA's comments on the vertical restraints block exemption is giving some indication of their attitude to enforcement? And I think the implication is, therefore, where the CMA is proposing change, does that mean they're less likely to enforce the old rules?
No. And I say that because what we have seen within CMA enforcement practice is a real focus in recent years on resale price maintenance in the context of vertical agreements. And what the CMA makes clear in terms of its proposal is resale price maintenance, it is not softening a stance on resale price maintenance. It's had a lot of feedback from businesses and practitioners saying, this doesn't really make sense. There can be efficiencies. Should you really treat it as a hardcore restriction? And the CMA has indicated it is very much minded to do so. So it sees resale price maintenance as something that will remain an enforcement priority. I think what we will actually see on vertical cases, particularly on resale price maintenance, is the possibility of more direct disqualifications. So previously, direct disqualifications have been the preserve of the hardcore cartels, so market share and price fixing between competitors. I think what we will see is the CMA looking to take direct disqualification cases against directors of businesses who've engaged in resale price maintenance as a vertical restraint. I think outside of resale price maintenance, the CMA is looking to provide more guidance in relation to active and passive sales, what that means in the new world of e-commerce, online selling. I think once those rules are set, again, the CMA will then seek to enforce as against those rules. So I think there is a general loosening of some of the restrictions, allowing there to be this decoupling of online and offline. But I think the more traditional restrictions, such as resale price maintenance and hands-on passive sales, for example, I think we will see the CMA still taking enforcement action against those and seeing those as areas to focus on going forwards.
And one of the other questions on this area is around how many distributors, especially traditional distribution agents, are international and often strategically are sort of set up at least a regional level, if not a global level. And therefore the questioner is asked, will this new approach and adjustments proposed by the CMA actually make any real difference to where you've got a distribution network that, for example, is across the whole of Europe?
I think that depends where Europe lands, as well as where the CMA lands. I think at the moment, where things are currently in train, there is a broad alignment. And I think that would then mean that in the short term, you hopefully shouldn't see too much difference. So if something's compliant in the EU with the EU requirements, by and large, that should then comply in the UK. That should still work. The CMA has not approached this trying to make things harder for business. I think they have recognised there is that need where you do have an international model to make the UK as business friendly as possible. So you don't duplicate a compliance requirement by having a very, very different regime in the UK. So I think if you are operating internationally, if the EU and the UK land in a similar place, hopefully that does then mean you can have something in Europe that would also comply in the UK. And it removes, I think, some of that issue around duplication. I think what will be interesting though is the detail. And I think what the CMA may do is be more permissive in some areas. So maybe you have something which is EU compliant, which you can then have in the UK, but loosen even further. So maybe the UK becomes a more permissive jurisdiction in that respect, that you can actually do more in the UK than in Europe. I think it's also worth flagging that the UK proposal is for a 6-year safe harbour, and that's as against the EU's 12-year safe harbour. So our block exemption for the UK will expire sooner. So once it comes in 2022, that'll be finished by 2028. The CMA can then review again and work out, is this still fit for purpose? Do we need to loosen more, tighten more? So we may see more divergence between the UK and EU coming down the track.
Okay, so if you're a EU or European manufacturer, you may well have, you'll have a European template distribution agreement. but it just might be that in the UK one, or in your negotiations with the UK distributor, there might be some opportunities to adjust it slightly, so you can retain an overall same framework, but perhaps make some adjustments in the UK to take advantage of some of the changes.
I think that has to be the way forward, to see it as an opportunity to take advantage of there being more potential flexibility in the regime in the UK.
Great. Now, while we've been talking, Sam, we've been having loads of questions coming in on Dawn Raid. So we've obviously engaged our audience, suddenly worrying about what happens when the CMA comes knocking. And actually the first question that came through is how can Dawn, you talked about CMA knocking the door at the reception, but if everyone is at home still, how do Dawn Raids work where the senior execs are working from home?
That's a really good question. I think that's one that the CMA will also be trying to find its way with as well, in terms of moving forward. Yeah, it may have some intelligence in terms of working patterns. So particularly if there has been, say, a leniency applicant who's come forward to give information about an infringement, they may be seeking information from that party to confirm, when is this senior person in the office? When do you normally engage with them, et cetera, et cetera. So there may be some intelligence on that. But otherwise, the CMA is able to attend. They can attend, and then word will be sent to the person, and presumably they will attend quite quickly. So the CMA's arrival at the office could well prompt their arrival subsequently. We have, in the old world, attended Dawn Raids where the CEO has not been on site, and it's been the case they have then turned up afterwards. The CMA, when it's entering a site, if it's acting under a warrant, for example, it is effectively able to search. It can go through IT systems, and it's much more focused at that point upon gathering the electronic, the physical data, rather than necessarily speaking to people. But obviously, if you are a CEO, you do want to be there to see what's happening and to have a sense of how this is all unfolding. So I think that's a really good question. I think it's one that we will see an evolving practice around. But for the time being, I don't think the CMA is going to hold up a Dawn Raid on the off chance that a senior person won't be in the office that day.
So can the CMA raid people at home?
Again, that's a really good question. This is an area where the CMA, in terms of criminal powers, they can conduct inspections at people's houses. They do have certain powers as well to conduct certain investigation under domestic premises. So far, it's not been the focus. It's not been where they have sought to engage. I think it remains an open question as to whether they will do that now in the hybrid world in which we're all occupying.
Okay, so what I'm hearing is that your judgment, and it can only be that because we don't know, is that the CMA probably will still Dawn Raid at the main business because it's focusing on securing IT and physical evidence and things like that. But it might not. If actually it's decided that actually we need to grab the CEO wherever he is because he's key, then he might well be raided at home.
I think if someone's involved in a criminal investigation, they can expect to visit at home or be required to attend a police station to have a conversation. I think in the normal course of things, businesses would be expecting to have a visit at business premises at this point in time. I think it would be quite a shift in CMA policy to start making domestic attendances the norm. I think they will still focus upon the commercial premises. Right,
so yeah, raiding at home, possible but unusual is probably where it is. Yeah, okay. But in your review of your Dawn Raid policies, it would be sensible to have a section on what happens if you get called by the office saying the CMA's turned up, i.e. take it seriously, get into the office if you can, if you're a relevant person, but also B, if they do come knocking on your door and contact you at home, what you should also do, just in case.
Yeah, I completely agree, David. I think where we are currently, I think it's a case of planning for all eventualities because there are a lot of known unknowns at this point in time. And it may well be that all stabilizes and settles down and a clear pattern emerges. But at the moment, I think having that contingency planning, I think that is sensible to be doing.
Yeah. And somebody's asked, because we're getting lots of questions on this in the chat, is would it be reasonable to expect that if there was a raid at home, that's probably going to be restricted to senior employees? We don't need to scare and wind up the more junior employees that the CMA might come knocking.
I think that is a good way to manage things. I think if you are talking about things like attendances at home, that should be to, I think, quite a select group of people. I think to give that message without a clear steer from the CMA on policy to a wide number of employees, I think that unnecessarily would cause concern. And I'm assuming that most of these people in any event will be using work devices. So even if they're at home, they've been on a work laptop. So that should be in a work server somewhere. So that should be in an office space somewhere, backed up on a server and update whatever. So there should be routes back to the main office such that doing attendance at domestic premises would be unnecessary in those circumstances.
Yeah, great. I suppose it's a good point though for your antitrust policy to remind people that even though they are at home, doesn't mean that they can engage in anti-competitive behaviours with their inappropriately. Just because you're at home doesn't mean that it's any different in how you operate your business.
I think that's absolutely right. And I think there's also a sense that if you're using, for example, personal devices, that somehow takes things outside the ambit of the competition authority. And depending on the powers they're exercising, it's clearly not the case. The competition authority can, just as the police can, they can take evidence that's in your personal possession on a personal device. You can't say to them, sorry, hands off that, that's my iPhone. It doesn't work like that in practice, I'm afraid.
Yeah. And then final question before we wrap up, turning back to the merger control. I mean, I heard very clearly that the old days, I mean, you'd probably say in the old days, relying on market share was probably not effective anyway, but that definitely isn't the case now. So if your business has got a merger strategy, it's thinking about it's going to be wanting to invest in certain areas and potentially buy organizations, what role should the in-house lawyer have in that merger strategy, given the antitrust issues?
Well, in-house counsel, I think in-house counsel is quite central to that role in terms of, if nothing else, stress testing and kicking the tires of the analysis. And I think sort of digging in to ask the questions that perhaps commercially it may be more comfortable to cross over, and to get into thinking about, there's lots of competitors. I think it's sometimes quite helpful just to have that voice in the background saying, can we really evidence that? Can we really make that clear? Can we present that effectively? How does that stack up? Just to ask those questions that perhaps if you're very close to a project, very enthusiastic about a project, you don't necessarily have the distance to take the step back, to then look at it a little bit more critically. So I think there is a clear central role for in-house counsel in that process.
Yeah, to be a critical friend.
Yes, and to avoid unpleasant surprises if the CMA does call this thing in and it all then falls over.
Great. Well, Sam, thank you very much. That's been really useful. And I'm sure, looking at the abundance of questions we've had, we've clearly had a lot of interest from our audience. So thank you, audience, for joining us. It's been a pleasure to have this engagement with you, and I really hope that our next big sort of seminar of this nature will be seeing you in person, certainly in the spring. As I mentioned, you will be getting the slides and a link to the recording so that you can review it and indeed share it. That will come around after we've done the last ThinkHouse session. So just to remind you, next Thursday, we will have the In-House Lawyers Guide to COP26, and followed by a session on what to do when contracts go wrong. And then after those sessions, we'll then distribute the links and the slides, etc. But thank you very much. It's been a pleasure. Good to see you all. Thank you.